Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular video, I'd like to talk about a certain provision of the Child Citizenship Protection Act. Now, as written, it does apply to a very specific situation, but there's lawsuits essentially all over the country and in the circuit courts to try to expand this particular provision. Now, here's the situation. Let's say, for example, that a lawful permanent resident husband petitions his wife who happens to have two kids. And at the time he petitions the wife, the kids are like 8 or 10 or 12 years old, underage. So the way it normally works is, let's say that after 6 years the visa number becomes current. In that case, when it becomes current, the wife and the children can all either adjust status if they're in the U.S. and they're qualified, or they can consular process from outside the country, meaning they do the necessary procedures to come in and get residency. Now, since the kids were under 21 at the time that the visa number became current, there was no additional petition that was necessary in order to bring them in. Just one petition from the lawful permanent resident husband to his wife, and that includes the wife and all the kids. Not a problem. Now here's the issue. Many countries, such as the Philippines, China, India, Mexico, it takes many, many years for a lawful permanent resident visa petition to become current. So many times the child will age out. So let's say by the time it becomes current, let's say the oldest daughter is now 22. Okay, so now because the older daughter is 22, prior to the Child Status Protection Act, what would happen is she would have to be petitioned separately now. Doesn't ride on the coattails of her mom's petition. She would have to be petitioned, and then what would happen is she'd have to wait all the number of years in order for that number to become current, minus a couple very narrow exceptions. And while this girl had been waiting since she was, let's say, 10 or 12 years old for the visa number to become current, because she turned 21 and it became current afterwards, she was essentially thrown out of the derivative beneficiary, and she was unable to consular process or adjust for many years. Well, the CSPA saw this particular problem and decided to pass a law to essentially ameliorate the harsh effects of aging out. So this is what happens now under the Child Status Protection Act. And keep in mind that what I'm talking about now is only if there's a lawful permanent resident petitioning a spouse that has kids underage, and then the kids age out. Okay, just that situation, which happens to be a lot of cases, but that's the case I'm talking about here. Now, what happens is under the CSPA, when the visa number becomes current, of course, the mother will be able to adjust her consular process. Then what will happen is the petitioner will then be deemed to have filed essentially a fictitious petition. It's called an I-130. That's what normally starts the process. But it'll be a petition from a lawful permanent resident to a daughter that's over the age of 21. Now, that goes under preference 2B, okay, whereas before it was preference 2A. Now, it takes many more years for a visa number to become current under preference 2B, but here is the catch. Here's where the CSPA comes in. When this fictitious I-130 is filed, it will use the priority date of the original petition of the father to the mother. So let's just say, for example, it was originally filed in 1996, and let's say it's 2011 now, and let's say it became current in 2003, something like that. Now, The way this will work is when this fictitious petition is made immediately upon issuance of the green card to the mother, what will happen is the priority date will go all the way back, sometimes 12, sometimes 15 years, whatever it is, under the preference 2B, whatever the preference happens to be. And when you look at the visa chart, you can look on it and probably it's already current or it's very close to being current. So instead of waiting another 12, 15 years or whatever it's going to be, it all of a sudden is current. So it doesn't really matter that you aged out if you fall under this scenario and follow the proper procedures under the CSPA, because you can come in very quickly by utilizing these provisions without a whole separate petition. And believe me, immigration is not going to write you back and go, by the way, you fall under the CSPA, why don't you go that route instead of the one that's going to take 15 years, which is what you've taken. No, they're not there to help you in that regard. So you have to realize you're under it, or you can call my office, call whomever you want, and any other immigration attorney who's familiar with the CSPA to see if you fall under it, and then we go from there. Now, here's the issue that is under litigation. It's the same type of situation I just told you, except it's under different preferences. So the preference I told you is preference 2A, where a lawful permanent resident petitions a spouse. Now let's say a U.S. citizen petitions her brother. Okay, that's fourth preference. Or let's say a U.S. citizen petitions a son over 21. That's first preference. Or a married son over 21. That's third preference. The litigation says that when any of these preferences happen, if the child's under 21 at the time of the petition, and then when it becomes current, the child is over 21, they should all be able to utilize this provision of the CSPA, not just preference 2A. So, there's some going back and forth, different decisions out, and of course I'll keep you updated on that. But that's how the current law stands in that regard. But hopefully you'll realize if you're under, or call somebody to realize you're under the CSPA, and you'll save many, many years of waiting if it's done properly. Okay, more on the coming videos.